Hello and welcome back to Vox Terra. Today, Sackett versus the Environmental Protection Agency, a case decided in May of 2023. A Supreme Court decision that is being roundly condemned by environmental organizations that I know and basically trust, like Sierra Club, Natural Resource Defense Council, and Earth Justice, and the Sunrise Movement. According to these sources, this decision strips away protection for millions of acres of American wetlands that were previously protected, and leaving them open to reckless development and pollution. And it does this how? By narrowing the definition of water that the EPA has authority to protect or regulate, under the authority granted to it under the Clean Water Act. And the majority opinion that lays out a new rule limiting their authority comes from the so-called conservative majority, with one notable exception. Well, just so you understand how all this here works, let's back up a little bit and take a look at the Clean Water Act. The Clean Water Act gives the federal government jurisdiction over navigable waters defined as waters of the United States, or commonly referred to as WOTUS. Now, the Act does not define WOTUS, or waters of the United States, but leaves that definition up to the EPA and the Army Corps of Engineers, or the Army Corps. Now, the specific issue of when a wetland can be protected by the EPA or the Army Corps of Engineers, or when it comes under federal jurisdiction, has been litigated in the Supreme Court in the past. And the determination has been that it is when a wetland is adjacent, and that's a critical word in this case, adjacent to another body of covered water, meaning covered by the Clean Water Act, like a navigable water. So what happened here is the so-called conservative majority redefined or come up with a new or novel definition of what constitutes adjacent in the Sackett case. And they not only rolled back the EPA's current ability to protect wetlands, but they also proactively, by this decision, cut off the Biden administration and the EPA and the Army Corps of Engineers' efforts to solidify the meanings of WOTUS so as to protect wetlands better, as that definition was coming under attack or trying to be weakened or restricted under the Trump administration. So now many media outlets are calling this decision a 5-4 decision, but that is not exactly what happened here. The decision itself was a 9-0. What it was, though, is that as I mentioned earlier, the so-called conservative majority wrote a majority opinion that created this new definition, or created this more restrictive use of the word adjacent, thus limiting the EPA's ability. So it was Justice Sam Alito who wrote for the majority, joined by Roberts, Thomas, Gorsuch, and Barrett, all justices, I believe, appointed by Republicans. Noteworthy. Now, articles like Reuters point out that it was 3 liberal justices, so-called liberals, and Brett Kavanaugh, a conservative justice, notably, so-called, who were part of what are called concurring opinions, meaning they agreed with the decision that in this case, the plaintiff or the people suing the EPA were in the right, but they did not agree with the Supreme Court creating this new restrictive use of the term adjacent and limiting the EPA's authority in the way that it did. So Sam Alito made a continuous surface connection test in order to determine if a wetland is truly adjacent and therefore worthy of protection or not. Meaning that before the EPA or Army Corps or somebody can step in and say, hey, this wetland's protected, here's what you got to do, here's the permits you got to get, buddy. Before you build something, before you do something, you got to prove there's a continuous surface water connection before you have that authority, administrator. Continuous connection to another protected water body. Well, Justice Kagan, in her concurrence, and she also cites Kavanaugh in her concurrence, meaning her opinion of why she doesn't like the court's majority opinion, says, paraphrasing her, the court went beyond a plain reading of the statute, disregards the ordinary meaning of the term adjacent, and disregards congressional intent when it set up the Clean Water Act. Kagan points out the Clean Water Act passed at a time when the Cuyahoga River caught on fire. That's how visibly polluted America's waters were. And the court, by making up or inventing or getting it from somewhere, this continuous surface connection test, is inserting something in the law that wasn't there or wasn't intended to be there. Moreover, this test that Alito wrote up here is not based on the reality of how water actually works. I heard one environmental science news reporter point out that many wetlands are connected to other water bodies by things called ephemeral water, meaning like a stream or a river pops up after an intense rain, or seasonal water bodies, like maybe the stream occurs in spring. Now, in addition to creating a new rule that wasn't in the statute, Alito also said, the court rejects, that's the word he used, rejects the EPA's arguments about the ecological consequences of a narrower definition of adjacent. So did you hear that or read that? The court under Alito is rejecting the EPA's conclusions about ecological consequences. That sounds to me, and like a lot of people like Sam Alito and his so-called conservative majority are placing themselves or just place themselves as the grand science arbiters, the chief environmental advisor of the United States, a role they don't have. Now, to understand a bit of that underreported money trail to all this, I want to siphon you from Earth Justice again. And they tell us that the plaintiffs, meaning the ones suing the EPA, the Sacketts, they own a lot of land near Idaho's Priest Lake. Their lot includes wetlands. The Sacketts claim that apparently they intend to build a house of some type on the property, and they dumped, citing Earth Justice, 1,700 cubic yards of gravel and sand into the wetland, and they did so without a permit. Now, Earth Justice claims, hey, they should have known better. Why? Because they own a construction business. They should have known they needed a permit, but they went ahead and did it anyway. Well, the EPA discovered the violation and ordered them to undo the damage. The Sacketts instead sued the EPA and are being defended by the Pacific Legal Foundation, a group that Earth Justice describes as a pro-industry group that seeks to dismantle key environmental protections. While looking at those two together, it sounds to me like maybe this is all part of a long game to challenge the Clean Water Act. And indeed, to wit, a lot of environmental organizations claim there has been a long game to do just that, sponsored by various industry front groups. So 3 pauses here. Look at the money. In earlier shows, and that's what most media isn't doing, when I cited the recent Supreme Court case EPA versus West Virginia, I took out some, as well as when I was talking about Clarence Thomas, I took some time to discuss the Federalist Society, an organization that is considered responsible for promoting all of these so-called conservative justices. And there I talked about some of the money to the Federalist Society that came from the Koch brothers that are infamous in environmental circles for climate denial and making their fortune in fossil fuel petrochemicals. My point here is that people who feel they are of conservative values might not agree with all of this environmental deregulation, and if they were aware of the moneyed interests promoting it, might really stop and pause. And in that show I did on West Virginia versus EPA, which is what I meant to say if I accidentally called it EPA versus West Virginia, in that case, the Supreme Court decided, hey, you know what, EPA? I know there's this thing called the Clean Power Plan that gives you authority to mandate clean power, but that does not give you the authority to say, you know what, we got to transition to renewables and get away from fossil fuels. The Supreme Court, in a sense, defended the fossil fuel industry, or at least the reckless elements of it. And as I pointed out to you in the past, both conservative as well as so-called liberal media outlets tend to ignore these money trails. Now, another food for thought is Earth Justice referred to the Pacific Legal Foundation as a pro-industry group, but I don't necessarily want to frame it that way. I want to frame it as pro-reckless elements of the business community versus maybe more responsible actors or emerging businesses. And if you're saying to yourself, what do we need wetlands for? Well, the Natural Resource Defense Council has an article stating we need them for storing vast amounts of carbon, curb the growing risks of floods due to climate change, recharge groundwater, improve water quality, and here I imagine they mean by filtering out other industrial pollutants and toxins, making wetlands crucial for both addressing climate change and the biodiversity crisis. They're awfully good habitat. And on a more mundane level, anyone who knows people who have bought homes that are built in wetlands knows there's often problems with sinking and flooding. So wetland development can often just feel like a scam. Well, to wrap this all up and leave it in a nice little package to conclude with, if we step back a little bit, we see a Supreme Court that recently stopped the EPA from using its authority under the Clean Power Plan to transition away from fossil fuel burning and towards cleaner power sources like renewable, and now is stopping the EPA from using its authority under the Clean Water Act to protect nature, the very nature, wetlands in this case, that serve to sequester all this carbon being burned by excessive use of fossil fuels, filter the other harms it causes, like carcinogens, and protect our clean drinking water sources and protect us from the flooding that climate change is bringing on. And doing so at a time when greenhouse gases are still on the rise, pathetically, and the climate feedback loops are kicking in, meaning that climate change is now taking on a life of its own beyond the initial having it set in motion by that excessive burning of fossil fuels. Well, hey, partner, I hope you found this video helpful, useful, interesting. If so, please make sure you're subscribed to my channel. You're clicking that notification bell so you know when I'm putting up a new video. Your liking, your commenting, sincere constructive criticisms are welcome. And thank you to my two patrons at Patreon, Bella Grissi, Environmental Coffee House. Please join in with that effort as well. And as always, until next time, peace be with you.